Colette Haynes.
All right.
Thank you. In regards to the PCC, Your Honor, we are requesting an adjournment just for some continued negotiations.
All right. With reference to the violation.
Yes, Your Honor. Ms. Haynes is prepared to admit to the bond violation today and provide an explanation.
All right. I'll accept the admission, but what's the explanation?
Your Honor,
Before this hearing even officially begins, it's important to understand what's really at stake here. This is not just a routine court appearance. It's a test of accountability, credibility, and how much patience the court is willing to extend. The case of People versus Colette Haynes centers around a bond violation tied to missed appointments, community corrections requirements, and drug testing obligations. On paper, the explanation sounds serious, a medical emergency involving diabetes and hospitalization. But in a courtroom, timing matters just as much as intent. Judges don't just look at what happened, they look at what was done afterward. As this hearing unfolds, you'll see a judge carefully walk through a timeline, questioning delays, gaps, and missed opportunities to correct the issue. You'll also hear a defendant trying to explain confusion, miscommunication, and uncertainty about the process. The tension here isn't loud, it's procedural, and those are often the most dangerous cases. So as you watch, ask yourself this: when does explanation stop being reasonable and start becoming avoidance?
Colette Haynes.
All right.
Thank you. In regards to the PCC, Your Honor, we are requesting an adjournment just for some continued negotiations.
All right. With reference to the violation.
Yes, Your Honor. Ms. Haynes is prepared to admit to the bond violation today and provide an explanation.
All right. I'll accept the admission, but what's the explanation?
Your Honor, it does state in the bond violation report that on the 22nd, when she reported she was visibly ill at the time, she explained to me that she has diabetes, and shortly after that went into DKA and did have to be hospitalized for a few days. So unfortunately, she ended up missing that new scheduled appointment as well as her first PCC. After missing the PCC, she did contact me, and we worked to get this case set to do a bench warrant recall. So she is willing to test. She is willing to comply on bond. She is sorry that she missed that appointment, and she's hoping to have an opportunity to go touch base with community corrections today and reschedule.
Thank you. But okay, I hear what you're saying, but when I look at this, all of the events that I have in this occurred at basically toward the end of September.
Yes, Your Honor.
I'm now almost 30 days out and nothing's been
This moment
corrected.
is legally critical. When the judge accepts the admission of a bond violation, the court is no longer debating if a violation happened. That part is settled. What matters now is whether the explanation justifies continued release. Medical emergencies like diabetic ketoacidosis absolutely carry weight, and courts do take them seriously. However, judges also expect immediate corrective action once a defendant is able to comply again. That means contacting community corrections, rescheduling drug tests, and keeping attorneys informed. What the judge is focused on here is the timeline. Nearly 30 days have passed, and nothing has been corrected. From the court's perspective, illness may explain a few missed days, but it does not explain weeks of inaction. This is where sympathy starts to erode. And viewers should ask themselves, if you were in this position, would you have followed up sooner?
Nothing's been corrected.
And Ms. Haynes indicated to me that she wasn't aware that she needed to make contact with community corrections because she had the bench warrant.
I didn't know that I can just go back there and.
Yeah, but once the bench warrant was cleared, she still. That doesn't even make any sense to me.
They told me that I had to wait when first they told me I had to do it online.
Do what online?
For the bench warrant.
That's fine.
Yeah, and I didn't know that the warrant was cleared until I come to court today. And I thought I needed another referral to go back to community corrections. I didn't know I could just walk back in there and do it all over again with a warrant. I tried to come up here and walk in on a warrant, but they told me that they only do it once a month, at the end of the month on Wednesdays. And that would have been yesterday, but I had received
Yeah, but where were you between that? All of this occurred September 2nd. I get what counsel's telling me, that at some point you're in the hospital for a few days.
I was
So
sick for
even if that takes me to the end of September, which is giving a lot of grace just in terms of time, I'm now here on the 23rd and nothing.
because they told me that I could not walk in on the warrant. And I didn't know that I could just go back to community correction.
You have an attorney.
Mm-hmm.
And Your Honor,
I was contacting the attorney, and when I was contacting the attorney, she was telling me that she didn't even, well, it was a he. It wasn't even her. It was a whole different attorney I had. We were texting back and forth, and I was asking him
This
questions.
exchange
and he was
highlights
saying
a
he was
pattern
in
the
court.
court
He don't know.
clearly
He'll
finds
find
troubling.
out.
Ms. Haynes
And then he told me
repeatedly
I could do
states
it online.
she didn't know what steps she could take, didn't know she could walk into community corrections, didn't know the warrant was cleared, didn't know she could test without another referral. But the judge immediately points out a key fact. She had legal representation the entire time. In the eyes of the court, having an attorney removes the excuse of total confusion. Judges expect defendants to ask questions, follow up, and stay proactive, especially in drug-related cases where compliance is non-negotiable. This isn't about one mistake anymore. It's about a pattern of delay. And when a judge starts emphasizing what should have been done, it's a clear warning sign. At this stage, the court is no longer weighing explanations, it's weighing trust. And that trust is slipping fast.
We were texting back and forth, and I was asking him questions, and he was saying he was in court. He don't know. He'll find out. And then he told me I could do it online, so I just did it online.
and Your Honor, I will say Ms. Haynes does want to resolve this case. She did make steps to take care of the bench warrant and to get the case back on track. So she's just hoping for another opportunity.
She's here on a drug case. Since the beginning of the case, she hasn't tested.
Understood, Your Honor.
I hadn't tested, Your Honor, because I didn't know that I could just, by me missing mine, I didn't know that I could just go walk back in. I thought I needed another referral. Or I would have went over there and walked in and
It's
tested.
not as though you didn't have an attorney, whether it be the previous attorney, whether it be Ms. Foster Tucker, to tell you what you could do regarding community corrections, if anything. But, you didn't abide by community corrections. You didn't appear in court. You get the court thing cleared up, but then you had the other thing. And I still, from the time of year, I don't have a test on you.
I can go take one today. I can go over there right now when I leave here. But I just need to know, am I
You want to
assigned?
say, I will adjourn her probable cause conference to October 30th, 2025, 9 a.m. Anything you want to say before I send you on the violation?
No, sir.
Well, at this point, she's not complied with everything. I'm going to revoke her bond, sentence her to 7 days, Washington County Jail. Defendant's remanded.
Is there a way that I can get somebody? I have my daughter here with me,
Ma'am, you probably shouldn't have done that.
but she only had a half a day of school today.
Ma'am,
Come on this way.
they'll figure it out.
Okay. Let me get her this. Yep, I'll give it. One back.
Ma'am, go with my bailiff now. Now.
This case ultimately comes down to one core issue: compliance. Despite a serious medical explanation and claims of confusion, the court focused on what happened after the emergency passed. Missed drug tests, lack of contact with community corrections, An extended inaction led the judge to conclude that bond conditions were not being followed. As a result, bond was revoked, and the defendant was remanded to custody for 7 days. The ruling sends a clear message. Courts may show patience, but they expect responsibility in return. This case is a powerful reminder that bond is a privilege, not a guarantee, and silence or delay can carry serious consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this.